Hi friends. So today we'll have discussion about a landmark decision of Honorable Supreme Court of India. This decision is about SARFAESI Act 2002. The parties involved in this matter are RC Polymers Private Limited and Mrs. Alpine Pharmaceuticals Private Limited. In this particular case, the Honorable Supreme Court has set aside the decision of Telangana High Court. Honorable Supreme Court held that it's not mandatory on the part of lender to reply to the representations or objections raised by the borrower in response to the notice issued by the lender under Section 13(2) of SARFAESI Act. To put the things in perspective, let me explain you broadly the scheme of things under SARFAESI Act. What happens, friends, suppose there is a borrower who has taken money from a bank. So the borrower is supposed to pay back the principal amount on due dates and also pay the interest. In case there is a default on the part of the borrower to pay back the interest or principal amount, the account becomes NPA. And once the account becomes NPA, thereafter bank has got all the rights under SARFAESI Act to take possession of the mortgaged property and auction the property to recover its dues in case the buyer fails to settle the dues otherwise. So the first step under SARFAESI Act is that the lender issues a notice under Section 13(2) to the borrower, requesting the borrower to settle the dues within 16 days time. To settle the dues, and in case of failure, unnecessary actions will follow under SARFAESI Act. And the borrower has to reply back within 60 days time from the date of the notice. Borrower is given a right to raise objections against the notice. The borrower may file a representation against the notice, and the lender is under legal obligation by Section 13, subsection 3A of SARFAESI Act to take into consideration the representations or objections filed by the borrower and reply back whether the objections or representations were found convincing and so therefore whether the bank is going to drop the proceedings or bank is going to continue with the proceedings. So Supreme Court decided that though a particular provision is there in the statute, nonetheless that is not mandatory, rather this is the directory only. And Supreme Court also took help of this doctrine of Waiver and Estoppel. So let me try to explain you in detail after all what had happened, what were the sequence of events, and what led Supreme Court to believe that this is a fit case for invoking the doctrine of Waiver and Estoppel. In this particular case, the borrower had taken money from other bank to acquire a unit. The unit was acquired and the property was mortgaged in favor of the bank. Thereafter, for whatever reasons, the plant was not running satisfactorily, and as a result, there were defaults, and the account became NPA. Once the account became NPA, thereafter, bank issued notice to the party under section 13(2) of SARFAESI to settle the dues and reply back in 60 days time as stipulated under the relevant section. Here buyer chose not to reply and not to make the payment either. However, the borrower uh, wrote to the bank that they acknowledge the default, they acknowledge the debt, and at the same time they want a moratorium of 12 months. And on its part, the borrower would infuse further funds and would go for techno-economic evaluation of the plant and do so many other things, to convince the bank about viability of the project. And so, after having discussions and deliberations with the borrower, the bank finally wrote a letter to its higher ups for for considering the request of the borrower to restructure the account. And at the same time, the bank put a stop on further proceedings under SARFAESI Act. Here, the borrower did comply with some of the requirements, did infuse funds partly, uh, but did not do what all the borrower was supposed to do. So as a result, the bank reinitiated the proceedings under SARFAESI. Bank took possession, symbolic possession of the property, and also took physical possession of the property. Thereafter, conducted auction proceedings, and however, for whatever reasons, this auction was not successful, and so naturally, bank at that point of time stopped the proceedings under SARFAESI at that point of time for the time being. This borrower again approached the bank requesting for reconsideration of the restructuring proposal, and offered so many things like further infusion and bringing in further technology. So bank again accepted the offer and allowed further moratorium. However, the borrower again defaulted on its promises. So the bank again went ahead with the proceedings under SARFAESI, and this time round bank was successful in getting a buyer. So the property was auctioned, and after due process of law, and sale certificate was issued to the highest bidder. Thereafter, this borrower got panicky and approached DRT, saying that all the proceedings under SARFAESI are illegal and not in consonance with the provisions of the SARFAESI Act. Therefore, all the proceedings should be held as null and void. After consideration, this DRT threw away the application of this borrower and closed the matter. The borrower thereafter wanted to file an application with the appellate tribunal, but that appellate tribunal was not in operation. Therefore, the matter eventually landed before Telangana High Court. Telangana High Court, after taking into considerations the arguments and counter arguments, decided that the proceedings under SARFAESI were not as per the provisions of SARFAESI Act, and therefore whatever actions were taken under SARFAESI, all those actions are null and void, and therefore the property would fall into the hands of original buyer. And as far the bankers are concerned, bankers can recover, bankers and whosoever is the purchaser, they can recover their dues under SARFAESI or under any other law. Telangana High Court decided the matter on mainly three grounds. First ground Telangana High Court took was Section 13, subsection 3A does not have any time limit to file representation or objections to the notice issued under Section 13(2) by the lender. Second ground was all the actions right from issuing notice under Section 13(2), thereafter taking position, symbolic position under Section 13(4), taking physical position under Section 14, and issuance of notices to the public in general and to the borrower in particular, and thereafter conducting auctions, issuance of sale certificate. All these actions are interlinked, interrelated, and because all these actions are interconnected, interrelated, therefore the cause of action is continuing on. Meaning thereby that under Section 17, which gives a right to the borrower to file an appeal before DRT, specifies that the application has to be filed within 45 days uh, from the day cause of action arises. So Telangana High Court said that because all these actions are interconnected, so the cause of action is continuing one. And so long this 45 days limit has been honored by the applicant, from the cause of action date, there is no violation of the requirement of Section 17 as far as limitation period is concerned. Third most important point was this Telangana High Court was very particular, very emphatic, and citing this some case, I think ITC case. Yeah, ITC case. Telangana High Court was of the view that reply to the representations or objections is mandatory requirement. And if this requirement is not complied with, so in that case that will render entire proceedings under SARFAESI as null and void. And because no reply has been given by the lender in this particular case to the borrower, therefore the entire proceedings were illegal, and therefore the property would again fall into the hands of borrower. However, at the same time, this banker and the purchaser are entitled to recover their dues under SARFAESI Act. Aggrieved by the decision of this Honorable Telangana High Court, the bank and the purchaser moved Honorable Supreme Court, and Honorable Supreme Court took into the consideration the fact that borrower had acknowledged the debt, borrower had acknowledged that they had committed a default, borrower had put up a proposal for restructuring of the account, and this proposal was time and again considered by the bank, time and again moratorium was given, time and again restructuring was done. So Supreme Court took the view that though there was no specific reply from the bank to the borrower as required under Section 13(3)(a) of SARFAESI Act. However, at the same time, the Honorable Court noticed that there was no specific representation or objections filed by the borrower in response to the notice issued by the lender to the borrower under Section 13(2). Supreme Court further took the view that the borrower right from day one knew it very well that this right is vested in him, and still they chose to relinquish this right consciously. They did not at any point of time during the proceedings, when the proceedings were on under SARFAESI and which lasted for years together, the borrower did not at all raise this particular objection at any point of time. So, in a way, the borrower had waived its rights, and therefore, subsequently, the Supreme Court took the view that subsequently the borrower is not allowed, or say the borrower is stopped from raking up the same issue at a later stage. So, on this ground, the Supreme Court set aside the decision of Telangana High Court and and allowed the property to remain with the borrower, with the purchaser. Thank you.